Welcome and good evening. Welcome to the Micklin Law Group's monthly webinar series. Tonight's webinar is called The Financial Impact of Divorce, What You Need to Know. Just give me a second. I want to make sure that the audio and visual is okay for those listening. If somebody could just post a notice maybe in the chat panel that you'll find on the right-hand side of your screen, just so I can you can let me know that you can see and hear me. You should be seeing the PowerPoint presentation on the screen. All right, I think I got a response, so hopefully that's going to be the same for everybody. So without further ado, let's jump into tonight's webinar. Let me give you a little background, what to expect for tonight, in case this is the first webinar that you've ever attended. It is scheduled for 60 minutes. I do my best to keep it on track and on time. I know everybody has responsibilities that they're going to be trying to meet. This is a one-way communication, so you should be able to see my PowerPoint and hear me, but I can't hear you if you were to be speaking by your computer. I will be taking questions. I wait until the end to take questions. I will stay as long as necessary to finish all the questions. But I usually recommend that you type them into the questions panel on the right-hand side in the middle portion of your chat panel, so that when we finally get to it, you won't have forgotten what we were covering when it came up. I also have uploaded the handouts, so you should see it on the bottom right-hand side of the chat panel, handouts in case you want to download a copy of the PowerPoint. Some presentations I do, there will be cases and statutes that are cited. I don't know if there are any or that many in this one today, but just ongoing in the future. Quick note, this webinar is being recorded and it will be posted on my firm's website, www.micklinlawgroup.com, as well as my YouTube page, Brad Micklin. It's being recorded in November of 2016. And that's important in case you're reviewing it somewhere in the future, that the laws and advice that's mentioned in here may have changed, so you always want to update to the current status. And lastly, just the reason I do these webinars is I learned over the 20 years or so of meeting with clients that there's so much information that a client needs, both in consultation and even as we go through their case, and it's so hard to give them all the information. It would take forever. I started creating this sort of library of information so my clients have a database to go to. Like I said, we post these on my website. I also have a video chat room, consultation room, so you can go and listen to certain questions and answers that are common, and watch all my past webinars also. Now let me give you a little background on me in case you haven't worked with me or you haven't met me in the past. This is me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I've been practicing law a little over 20 years now. I'm a member of the New Jersey and Pennsylvania state bars. I omitted Pennsylvania from the screen because I'm not active there any longer. I limit my practice solely to New Jersey. I can appear. I'm licensed to appear in both state and federal courts. I have a background in civil litigation, having clerked for Judge Austin in the special civil part, then doing complex commercial litigation with Kessler & Associates for a couple of years after, before opening my practice in 2001. The Micklin Law Group itself is concentrated in divorce, family law, and estate planning and litigation. My area within those areas is to handle the high conflict, high net worth cases, the more complex litigation. We have a number of associates and paraprofessional assistants that help with the other cases. Here's some background of accomplishments, me or my firm. I put these up not so I could boast, but those that have not worked with me, or even those that are working with me, it's just nice to know that you're getting somebody with a little background and get some sense of my expertise and my desire and ability to represent my clients well. So with that being said, let's move in to talk about what we're going to cover. So I'm going to be about 8 topics we're going to try to cover tonight. It's a lot of information. I'm going to move kind of quickly through it because I'm not sure exactly how long it's going to take to get through. So let's move quickly through the list. We're going to talk about alimony and the different types. We're going to talk about Pendente lite support, which is temporary alimony support that lasts through a divorce case. We're going to talk about child support issues, always very important in divorce work. We'll talk about other issues in support like college contribution, emancipation, other child support related issues. Talk about some of the tax issues that alimony and child support and other topics that are affected by divorce and are involved in divorce cases. 6, we'll talk about attorney's fees, always an important issue to not only my firm, but to the clients also. We'll talk a little bit about life insurance and what role they play in divorces. And then lastly, we'll talk about the estate planning concerns and how they change both during and after your divorce. So let's move right into alimony, which is also known as spousal support. Alimony is just the legal term for it. The purpose of it is to assist a spouse who's lost the opportunity to advance during the course of a marriage, usually referred to as an economically disadvantaged spouse, meaning they gave up the right to advance during the course of marriage and now they need some form of compensation to remedy that. The purpose is to allow the lower earning spouse to lead a comparable lifestyle. I'm going to try and highlight here for you. The word comparable is very important. People think that alimony is supposed to be so they can live the life they lived while they were married. That's not the case. It's not an equal life. It's a comparable life. It means it has to be somewhat similar, but not equal. Because it just simply can't be. When you have one house that divides into two, things need to change. So the comparable lifestyle standard causes a lot of confusion for a lot of people. A little more about, now let's talk about what the court considerations will be when they look at alimony. There are about 14 in the statute, the alimony statute. I focus on a small handful here. The ability to pay, the length of the marriage, the age and health of the parties, standard of living, earning capabilities, and marital property. The last one I find is the least utilized by courts. In my experience, mostly they're really looking to the length of the marriage, the lifestyle of the marriage, the higher earning ability, spouse's ability to pay, and the lower earning spouse's ability to earn. Those are really what the focus of alimony is going to be. Now, there are several different types of alimony, so let's talk about the different types of spousal support. There are essentially 4. It's permanent, which is now called open durational, but it represents about the same thing. Rehabilitative, limited duration, and reimbursement. The first open durational has been changed now so that it acknowledges that even permanent in the past did terminate for certain circumstances, like substantial change of circumstances, retirement, remarriage. Rehab support is to help somebody rehabilitate themselves or to raise up or advance in a certain career or in a new career so that they will no longer need spousal support, so it's usually of a shorter nature. Limited duration is for a specific term. It cannot be extended beyond that term. It can be modified in amount, but not in length. And reimbursement alimony, probably the least common, at least in my experience, is a form of alimony for one spouse that has sacrificed either time or monies to help the other spouse advance in his or her career. Sort of the opposite of rehabilitative alimony. It's a sort of a repayment for the sacrifice that was made because somebody now has an advanced degree in higher earning powers because of the other spouse's efforts. Pendente lite, a very difficult topic, a very important one to understand. It is, as I said before, temporary support that's ordered throughout the course of the litigation. It is not a permanent award. The purpose is to maintain the status quo. That's a very important term also, something that you want to focus on. Going to this comparable lifestyle analysis, again, status quo often is hard to define, and it's also hard to maintain when a house is going through a divorce, especially if one spouse has relocated and now we have 2 houses. In my experience, it also is typically larger than the final support order. I will go into a little more deeply, I think, later in the slides, but the status quo that's being maintained is usually much higher than the expectation or the need that a spouse has ongoing. Pendente lite is more of a large Band-Aid so that nobody's suffering economically during a divorce. and then the final award is more based on what is needed long term. So it's often going to be lower. Not always, but often. Again, the purpose is so that there's no disadvantaged spouse. We don't want somebody to have to transfer assets or liquidate assets and one person having more of a comfortable time through the divorce. Conversely, like I said, alimony is determined based on the ability to pay and the other need. That's not the case for Pendente lite support. It's to maintain sort of an equal footing to the extent that's possible. Some certain important issues when you're discussing Pendente lite support that are often overlooked. One is the tax allocation. Support or alimony is deductible from the person who's paying it and taxed to the recipient. Pendente lite support is different. It's usually considered unallocated for tax purposes by the judge who is ordering it. And this creates a conflict. In the court's perspective or view, unallocated means it's not deductible necessarily and may later be determined to be so. The IRS guidelines in the cases I've read say that if it's unallocated, it's actually deemed to be all alimony. It's a conflict I haven't been able to resolve in litigation or with judges thus far. It's something that I just keep in my mind for settlement purposes and trial issues. So you want to try, depending on which side you stand, to either force the court to order Pendente lite and indicate whether or not it's going to be deductible if you're the one paying it. If you're the one receiving it, you don't want the allocation, you're arguing that it should remain unallocated. Like I said, it's something that's not as significant in the beginning when you're getting the support, which is why it's overlooked, but it is very significant when settlement talks start later in your case. Moving on to the next significant issue in most divorces, child support. Now, child support is determined by what we have in New Jersey as the child support guidelines. And I believe many, if not most, states have guidelines. And what it does is it takes a income proportionate distribution to determine what child support is. It's sort of plugging numbers into a computer program now. The obligation is going to either be weekly, sometimes it's going to be bi-weekly if their pay period is on a different schedule than weekly. It's going to make certain adjustments up or down depending on who has how many overnights. There's going to be adjustments for whomever is paying medical insurance, a pro rata or proportionate reduction for that person. If there's extraordinary or recurring medical expenses that can be built in specifically to be addressed, if there's certain medicines or diets that are necessary. Daycare costs, if it's work-related, get added in and distributed proportionately. And then anything else that may be necessary for the support obligation the court could determine. There's also some other deductions I'm not going to go into, like the alternate dependent deduction if you have other children or other support obligations, but that also can be something that is considered in an adjustment for child support. All right, let's take a second to look a little more closely into some of the things that child support is deemed to include. First, it includes or is considered to include the first $250 of unreimbursed medical expenses per child per year and all extracurricular activities. Now, the thing about child support guidelines, at least in New Jersey, is they're presumed to be accurate and in the child's best interest. But another thing to remember is that the court does have the ability to deviate if the guidelines are not sufficient or not in the child's best interest. And this is important because, first of all, $250 per child per year of uncovered medical expenses usually is the most that the average child or family encounters. But extracurricular activities can be very, very expensive on families. And I think given the way that parenting has changed in the last couple of decades, 20 so years ago, you played out in neighborhoods until the sun went down. Now everything is play dates and extracurricular activities and soccer camps, and so the cost of extracurricular activities, I think, in the last 20 years has substantially increased for the average family, and it hasn't changed the fact that it's considered to be part of the child support guidelines, and it's largely insufficient. Child support is not deductible like alimony is. It's not income to the person receiving it, so there's no tax consequence whatsoever to the payment of child support. And let's take a look at a couple of the expenses that are included in your child support calculation under the guidelines. So when you're receiving or paying child support, these are the expenses that it's deemed to cover. I'm not going to name each one of them out loud. I'll give you a second to look at them. Essentially, child support has a breakdown in the guideline history or the intention of providing a portion towards fixed cost, a portion towards variable cost, and a portion towards controlled cost. Now the guidelines break it down weird, like it's 27% in one and 24 in another, and like 32. But I say generally look at it as a third. So it's a third of your fixed, a third of your variable, and a third of your controlled. Now fixed are usually things like housing, transportation, health insurance. These are costs that don't usually change much. Your variable costs, things like food and clothing, entertainment, miscellaneous and childcare, they change often. Then when you get things like other expenses, miscellaneous and childcare are controlled, because they're sort of a blend between fixed and variable, because they don't always stay exactly the same, but they may not change a lot. So the theory is that all of these expenses, they're fixed, variable, and controlled. The person paying support is paying 1/3 of those per child, and which is important to know only so that you realize when it is time to ask for deviation of the support guidelines. If you have exceptionally large costs in one of those areas, it's not going to be accounted for in your child support, so it may be a reason that you need to deviate. Quickly moving into other issues of support, one important one, if you have young children or long-term alimony, is cost of living adjustments, also referred to as COLA adjustments. These are supposed to be made every 2 to 3 years, but it's not always. In my experience, cost of living is often regularly done if you're paying through the court, through probation or wage execution. But if you're receiving direct payment, it doesn't always necessarily happen. And if you're not getting it, that doesn't entitle you to go back and ask for it, even though other people are getting it automatically. So it's something important that you need to consider as you go through a divorce. If you're the paying spouse or parent, you don't want it to go through court because you'll be subject to the automatic adjustments. But if you're the receiving or recipient, you want it that way so that you get the increased, or you want to put into your settlement agreements that future cost of living adjustments will be automatically included. Extracurricular activities, I touched on this before. They can be very expensive as a child grows. They're deemed to be included in child support so that you're not going to get, if you're the custodial parent, you won't get anything further for child support in the years to come. I usually recommend that you agree to some division of extracurricular activities in a settlement agreement in a divorce case, or at least you put in that you're contemplating changes in the extracurricular activity, maybe even listing what they could be. Some clients have even gone to the extent of listing what the specific activities are and that are to be included. It's important to know that it's an issue you should work on. Emancipation is our next issue. This is the time where you're relieved of your obligation to support a child. Now, under the statute, emancipation happens at marriage, entry into the military, by court order, or attaining appropriate age. I believe there's a law that's coming into effect that makes it automatic now at 18, where it used to be presumed to be at 18, but the person who was paying support still had the burden of going forward into court on a motion or a consent agreement to terminate child support. I believe it's now going to be changed as of 2017, that it's automatic, but I've yet to see how that actually plays out. And that's important because some children are never off of child support. They may have special medical or emotional, psychological needs that keep them from living on their own. They may have, injuries that could impact their ability to self-support themselves. The term for determining whether a child goes off of child support is that they've moved beyond the sphere of needing parental influence, meaning they don't need help from their parents anymore. And not every child reaches that point at the same place, but we're not sure how it's going to play out with the new change of the presumption. Along the similar lines of emancipation is college contribution, which may or may not come at around the same time. Now, the courts have a number of issues that they need to consider when it comes to college contribution. There's a case, Newberg versus Enrico, which will set forth in great detail the analysis a court is supposed to go through. Essentially, these are the factors. I'm going to highlight, my opinion is financial resources, ability of financial aid, and the child's relationship to the paying parent are probably the more important ones that the courts will consider when trying to determine whether or not child support and college contribution will be mandated. The reason is quite simply, child support is mandated because the state doesn't want to have to support people's children. College is a different issue. If you're married, you can't be forced to pay for your children to go to college, but if you get divorced, the court can order you to pay for college. So there's an underlying fundamental unfairness in the college issue, so they make the test very rigorous as opposed to the receipt of child support, which is a presumption. Okay, another issue that's important to consider is how payment of support is going to be made. As I mentioned before, you can either pay directly or through probation, and that affects the cost of living adjustments. There's a distinction in here that I probably should have added. Probation can also mean a wage execution, because if you have a wage execution being taken from your pay and going through probation to the recipient, or the person who has to pay can make a payment directly to the probation department and it goes to the recipient. So it's going through the same channel, it's just being taken a different way. The presumption for most support payments, especially child support, is that it be paid through probation. It allows the court to monitor lateness. I think it's better for both parties. It's certainly much better, usually much better for the recipient, because it's tracked. When it's delinquent, the court will often do its own enforcement. The negative for the recipient is sometimes there's a much greater delay in getting the support, and if it's not done accurately, it takes even longer to get it. From the person who's paying, again, the advantage is it's one less contact you have to have with your ex-spouse. The disadvantage is if you miss payments or you change your employment, there's going to be possibly enforcement techniques and applications that are almost automatically issued against you. So as I was saying, it allows probation to do the execution for you. Moving, hopefully, I think we're on pretty good time, but let's talk about some of the tax issues. Tax issues are another very important topic that need to be considered throughout a divorce. The income tax rates, which are often not even addressed. But these rates are going to be affected by the separation, because the difference in tax rates between not only married and single couples, but also your tax rate when you're living together or not. You get taxed lower as a married couple, but your income is higher, which could push you into higher tax brackets. So you need to understand the interrelationship between those. And it's very important when it comes to spousal support. Here, the slide is saying, income tax is offset by a decrease in household income. That happens when you split up two households. But what's really important is to understand the tax rates so that you know the effect of your alimony awards. Your tax income will decrease when your household income decreases. Say your spouse moves out or you divorce or your income is down, your tax rate will probably go down. But if you receive alimony, it may bring you into a higher tax bracket and actually negate the actual payment of alimony if you don't look. Like, for instance, the difference in the tax rates for somebody making $37,650. I was going to write this, but I don't think that the writing will be legible because my normal handwriting is poor. So the tax rate for somebody making $37,650 is 15%. The tax bracket for somebody making $1 more, $37,651, is 25%. So let's say you have a modest earning spouse who's making like $15,000, and with alimony added, the total income he or she is receiving is $36,650, which is the cap of your 20 or of your 15% tax bracket. So in that scenario, at 15%, they're going to be taxed $5,647, which leaves them a net income of $32,003. Now, if that same person gets $50 more in child support, in alimony, their income would then be $37,700 instead of $650. But that $50 pushes them into the 25% tax bracket, which means the tax will go from $56.47 to $9,425. The net income being $28,275. So that $50 increase in alimony gave almost a double tax burden, another $4,000 worth of tax, and actually you come out with less income. So it's very important to consider the tax rates when discussing alimony for both the recipient and the paying spouse, because sometimes you're losing the actual benefit that you're hoping to achieve. Another tax issue is to understand how taxes are affected by equitable distribution, or if there are going to be at all. Equitable distribution, for those who may not be aware of it, is the division of assets and debts inside of a divorce case. Now, it's important to note it's equitable distribution. It is not equal distribution, although in most cases I've seen that the courts do deem it to be equal. There's very little reasons I've seen the court to decide to unequally distribute assets that were at least acquired during the marriage. Now, it can be different when there's premarital assets, but I'm not going to go into that. But in my experience, it's going to be equal distribution of the assets and debts acquired while you were married. But here's what the court is supposed to consider, and I guess to some extent maybe they do. Length of the marriage, contribution, the ability to earn after the divorce, child care responsibilities, other assets, and other factors. Again, this is what the statute reads. In my experience, it's really not, absent some kind of extraordinary circumstances. But what is important to know about transfers in divorce are the tax aspects. First, the distribution of assets do not trigger any tax consequences. They are zero affected by tax as long as they're being transferred by incident of a divorce. However, that doesn't mean that later, when you try to sell or change the assets, you're not going to have tax issues. Capital gain taxes are very important to realize. If you're, for instance, dividing a house and a pension, and commonly one spouse will want to keep the house and one spouse may want to keep the pension, there could be a very significant capital gain tax on the sale of the house or the liquidation of the pension that would reduce the actual asset that you're receiving, and you're not contemplating, you're not building that into the distribution scheme in the beginning. You need to know what the effect of the tax, if any, will be. You should also look at, while you're talking about taxes, to the effect of the penalties and fees that you pay with pension plans if you're going to need to take them before retirement, because that can greatly reduce the value of the asset that you might be receiving or possibly waiving. So learning and understanding what the tax consequences on the sale of your property later is going to be very important in distributing your property carefully. A couple more quick issues I want to move into with tax issues. One is the dependency deduction. Very big issue. I see a lot of parents spend a lot of time arguing over this deduction. Let me give you a quick caveat too. I am not an accountant. I don't profess to be one. So with any issues in divorce, I always seek an accountant's advice when they're complicated issues. I recommend you do the same. But with the dependency deduction, it's a $2,000 deduction for each dependent. Commonly, the courts will alternate the deductions between the parents. If there's one child, if there's more than one, they split them until there is only one that remains unemancipated, and then they rotate those. But essentially what the courts try to do is to balance them so that everybody shares in them. One thing I usually recommend before we move on to another point is sometimes one parent will benefit more from the deductions than the other if there's significant income discrepancies. I often say to let the person who benefits the most take them, but share the benefit received with the other person. So you're maximizing everybody's receipt or everybody's tax consequences. There's also a child credit for children under the age of 17. We'll reduce about $1,000, I think, from taxes. There's one other thing I didn't put in here that I probably should have mentioned. That is daycare and day camps will often have a tax consequence or tax savings that needs to be allocated both when you're discussing child support and additional child care costs. Moving into my favorite topic, attorney's fees. Attorney's fees are important because some fees that are paid in a divorce by a client, not necessarily to an adversary, we'll talk about it, can be tax deductible. So if you're giving advice for alimony, property transfers, dependency exemptions, the fees used or the fees incurred for those issues may be tax deductible on your tax return. Generally speaking, these topics, alimony transfers and exemptions, are tax-related issues. So if it's legal advice regarding tax-related issues, they tend to be potentially deductible. Now, there is a cap. It's 2% benchmark for miscellaneous expenses. This is where you want to go to an accountant to make sure before you start taking the deductions. You may even want to speak to an accountant before you settle your case to find out if you're going to have these additional tax savings. It may help you to know that, so you'll know whether or not you have extra monies available when it comes to discussion of alimony and child support expenses. It's important to remember that if you pay your other spouses, you do not get a deduction for that because you don't know if it's going to be allocated towards the tax-related issues or not. What's important when you work with an attorney is to have that person allocate on their bills what is deductible or not deductible, or at least make sure that the bills have enough description so you can determine once you review them whether or not they were related to any tax-related issues. At the Micklin Law Group, we try to put a sufficient amount of detail into every entry so that you know not only what we're doing with great detail, but also later if you need to allocate it for income tax. Another important topic that's very common in divorces is life insurance. Most divorces will have a provision for life insurance to be maintained by one of or both of the spouses. Generally, it's going to be used to ensure the payment of child support or alimony, or the loss of child support or alimony. So in case one of the parents dies prematurely, you want to ensure that the obligations that are being agreed upon and the life changes are being based upon will in fact continue after that spouse's unfortunate demise. It's also important you should look at the cost of the policies and how they may increase. In a lot of cases, there will be future options to remove or reduce child support, or life insurance. Say, for instance, you have a 10-year alimony obligation. Once you're 5 years into it, you might have a provision that allows you to keep 1/2 of the insurance coverage because only 1/2 of the obligation remains. That may be difficult to do, so you may want to factor into what's going to be available to you in the future, whether you're the one receiving the benefits of the life insurance or you're the one taking the policies. Now, there's different types of life insurance policies, so you want to consider the different ones, what's going to be best for your situation, both financially as well as what you're trying to cover or protect. First, the most common is a term policy. These are going to be for a specific period of time. They have no value other than the potential death benefit. They expire at the end of the term, and they have no value at the expiration. But they are the easiest to obtain and usually the least expensive. Next is a variable life insurance policy. This is a life insurance policy that usually has a death benefit and some kind of insurance component or investment mechanism. So you're investing premiums, you'll have a cash value apart from the death benefit. So if you put, you may have $1,000 cash value that builds up. The death benefit can be payable to one person. The cash value may be payable to another. It's also a good tool for retirement planning. So if you have a term, not a term, but if you have a limited amount of time that you're going to be paying alimony and it's going to end at a time where you anticipate being alive and healthy, or at least alive, building the cash value into this policy may actually inure to your benefit for retirement planning. So it may be worth putting a little bit extra money up, since you're already going to be required to get the life insurance, to take out a variable life insurance so that when it's over, you actually have some built-in value. There's also many other types of life insurance I'm not going to go into. I think it's a little beyond the need for a divorce planning. But what is necessary for divorce planning is estate planning. Before, or like right before and right after your divorce are important times to review your estate planning. I generally think every year or two is important, or any change, but the divorce is a major change. Main reason is, first, once you file a divorce, your will is revoked by operation of law, which means it no longer exists even though you have it. Even if it was not your intention, it's automatically done. And when you pass without a will, if you were to die shortly after filing a divorce, your property will pass under what's called the intestate statute, which means that the laws determine who gets your money. In a lot of cases, it would be a surviving parent that you may or may not want. It could be your surviving spouse that you may or may not want. Also, as I'm mentioning in this slide, if you're leaving money that's ultimately going to go to your children, without planning, it will go to the other parent to manage. That may not be what you want. You may not trust their ability to manage it. You may just not want them to. So without planning, you lose that ability to control what happens to the assets once you pass. Another issue about divorcing and estate planning is it can affect your estate tax purposes. It's usually for higher net wealth clients now, but because obviously the economy is on an upswing and a lot of people have a substantial amount of life insurance, which is an asset for probate or your estate, it's something you need to consider. So right now, married couples can pass an unlimited amount of assets to one another without any tax estate consequences. Once you're divorced, you can pass $5 million. Now, to most of the people who are listening to that, that's not going to matter. That while you were married, you could have passed 10, but only a single can pass 5 million. But it's important to understand, at least, that some people in higher net worth situations or with substantial life insurance are going to have these issues. A single person can often pass property to beneficiaries who then receive the inheritance tax burden or an estate tax, or actually usually not estate tax, but inheritance tax, very common, or estate tax can be at least commonly in New Jersey. What happens is if you pass somebody a piece of real property, for instance, and it's worth $700,000 under current estate law, that person is going to have an inheritance tax. If they're a certain family member, if they're a certain relation to you, they may also have New Jersey estate tax currently in 2016, and that person may actually need to sell the house in order to pay these taxes. Now remember, as I said at the intro, this is in 2016. New Jersey's estate tax laws are going to change in the next year or two, so the estate tax issues that I'm talking about will no longer be important, but the inheritance tax issues are very important. Inheritance, simply put, is usually significant for extended family members and friends, or anybody who's not an immediate family member may have a significant inheritance tax burden to an inheritance that may not be contemplated when you make your estate plan or as you're going through a divorce if you have no estate plan. That looks like all the information I did want to get through. I may have rushed it a little bit, so I apologize, but I did want to keep it as close to an hour, and I wanted to leave as much time for questions as possible. So I'm going to see if anybody posted questions while I was rambling along. Okay, I don't see any. Does anybody that's listening have any questions that they want me to address? Anything that seemed to be unclear? All right, it's got a question coming up. All right, what happens to pensions? Well, pensions are generally, I'll address that as much as I can in both divorce and the estate planning issues. Pensions are generally distributed in equitable distribution of a divorce, just like any other asset. So they are going to be considered a marital asset that gets divided usually 50% of the contributions that were acquired while you were married. The way that normally is done is we hire like an actuary or a company that actually goes in and evaluates all of the assets that are held within the pension, because it's going to be typically comprised of many different investments and many different shares acquired over periods of time. So this actuary will actually go and look at essentially each share to find out when it was acquired and how it's changed in value, so that the shares that were acquired while you were married will be distributed to the other spouse pursuant to your divorce agreement. It'll be affected by or effectuated by what's called a qualified domestic relations order, which is commonly referred to as a quadro. That's a court order that allows a pension to be divided, because the pensions are created under a federal law that indicates that it can only be paid to the employee and controlled by the employer. The quadro is a court order that allows the employer to create a sort of secondary account for the non-employee spouse to receive the pension distribution. Now, as far as estate planning goes, pensions are generally considered non-probate property, which means they don't pass through your estate. They will typically have a named beneficiary, and upon your passing, it will go directly to that named beneficiary. Now, if you don't have a named beneficiary, it will pass through your estate. In many cases, if you fail to change the beneficiary of your pension after a divorce, you may be able to go to the probate court and successfully argue that it wasn't the decedent's intention to let his or her ex-spouse receive the pension. He or she was just unable to promptly effectuate a change of beneficiary. But it can't always guarantee that that's going to happen. So what we do when we end our divorces, we tell our clients, first thing you need to do, close all joint accounts, change all beneficiary designations, pensions and insurances. I got another question. I'm just going to find my cursor. Could both parties agree on a percentage for child support? Meaning, can the parents agree to a different amount of child support or a percentage of child support different than what the child support guidelines would provide, is how I'm going to read that question. So tell me if I'm reading it wrong. Because there is some support in the child support guidelines to say that the guidelines itself are based on a range of between 17 and 22% of the paying spouse's gross income, but that's not really how the calculation is done. But if the question is, can parents agree to a different amount of child support? Yes, you can. As I said earlier, the child support guidelines are presumed to be correct, but the courts are allowed to deviate if the deviation is found to be in the children's or child's best interest. What I do with my clients who are trying to deviate from child support in either a consent order or a settlement agreement is to put in language that says the parties or the parents are agreeing to deviate from child support because they think it's in the child's best interest, and even specifying why that may be. You can put in because the extra cost is going to go through X, Y, and Z, or the reduction is going to be so that the paying parent can provide a better lifestyle when the child is visiting. So you can put in whatever language you want. What is important, though, to note, there was a recent case in the past year or so, maybe even two now, that said when parties deviate from a support guideline, it's important to note in the document that's ordering it, whether it be a consent order or an agreement, the reasons why they're deviating and what for the deviation is for, and whether or not you intend that deviation to be utilized in the future. Meaning, if you're agreeing to a different amount of child support currently, in 5 or 10 years when child support is reviewed again, do you intend to have that same deviation and the same reasons for deviation to be utilized then? And if it's not in the instrument that you're getting the child support set, it makes it very complicated for a court in future years to determine whether or not the deviation should continue or not. Hopefully that was your question, and hopefully that gave you the answer that you needed. If not, just post another question. All right. Another question is, do you recommend always using an attorney even for amicable divorce? In, I guess, Washington State, where I am, it's relatively easy to divorce, but I'm not comfortable pursuing without legal advisement. I do always recommend that you use an attorney, and it's not because I am an attorney, because I'll be the first attorney to tell you, don't hire me if you're not going to get the value of the money that you're spending. But there's a number of reasons. First, when it comes to a divorce, the issues are so complex that you can't possibly understand. And especially if you're going to have alimony or you have children, you're not going to know what problems may exist in the settlement agreement. You don't know what kind of issues and problems you're going to have in the future. You're not capable of realizing what you may need in your agreement today to protect you and your children in the future. And only a good, experienced matrimonial attorney can really tell you that. But also, you want to make sure that you do it and you do it right. So when it comes to drafting documents and filing documents, you're not going to know how to do that. You're going to go into court and a judge is going to say something to you or ask you a question, and you're going to be concerned of what your answer may suggest, and then you're sort of not paying attention now to the judge because you're worried about how your answer is going to sound. It's very, very difficult to handle divorce on your own. I'm a divorce attorney for over 20 years. When I got divorced, I hired an attorney because I needed to make sure I had somebody that was objective on my side, that could handle, the issues that needed to be confronted with professionalism and objectivity. And as a client, you just don't get that usually in a divorce. I've have a little problem with my cursor. I'm going to scroll down and see if we have any more questions. All right, I'm not seeing any more questions. I will hang on for another moment or two to see if anybody thinks of any that I didn't get to address. Going once. Okay, new question. If you have a two-family home, both parties agree to keep names on the deed. I don't know if your question is, can you do that, or what are the potential benefits and pitfalls? So I'll answer both questions and you tell me if you need more. You certainly can do it. You can do most anything you want in a settlement agreement, as long as it's not contrary to either the law or public policy. The benefits and detriments, one important thing to know is when you hold real estate as husband and wife, depending, as long as the deed is worded the way it typically is, when one spouse dies, that property automatically goes to the other person. If you're agreeing to continue to hold the property once you're divorced, an ex-husband, ex-wife, you may not want that spouse to receive the property, the other half, if you pass, and vice versa. You may need to change the deed. You may need to draft a different deed showing that even though you're ex-husband and wives, you're holding property in such a way that each of you can pass your property to your heirs and not to the other spouse or ex-spouse, unless it's your intention that the other person gets it. But you want to make sure that you understand how the property passes between those two different types of deeds and make sure that your agreement indicates what you're doing. You also need to indicate who's going to be responsible for the carrying costs. You need to contemplate in the future if there's going to be a sale and capital gains, how it's going to be divided, upkeep of the property. What if one person wants to sell it and the other can't or doesn't want to? So there's a lot of issues. I guess the answer to your question about whether you can is you certainly can. Whether or not you should is going to be based on how good of a relationship you have with the other person and the true financial benefits long-term you can expect to have from them. All right, I got another question. Can a CIS be updated after being submitted? Yes, it actually is supposed to be. Given the average divorce case, that's going to take you anywhere between 8 and 16 months. You're going to file your initial case information statement in the beginning of the divorce, and you're always going to update it. One, it's a summary document, so it's never going to be fully accurate. And as your case develops, you'll have more information that will help you supplement your CIS. You may also have temporary support obligations that change your CIS. And most importantly, as you approach the end, you're going to have potentially anticipated expenses that you're going to have once you divorce. Like if you're living together through the divorce, your expenses are going to substantially change when you separate. You want to build that into your case information statement. You may not know that when you begin it. So yes, you absolutely must update your case information statement throughout a divorce case. Okay, there's another question. I keep losing my cursor here. All right, here we go. All right, so the question looks like it was related to that other two-family question from before. Can I own one unit? Tell me if I answered that question when I discussed the question about having a two-family. Because yes, you can certainly own one of the units. The concerns and things you need to be worried about, the legal effects of the title and what happens if one of you die, and the long-term costs and expenses and how they're going to be shared or managed. Okay, again, I'm going to hang out as long as needed for more questions, so I'll give another minute or two to see if any pop up because I'm not seeing any just yet. Oh, okay, another one. What if one party went and got a quitclaim deed on the house? Can he benefit from any interest after the house is sold? I'm not really sure what you mean by if one party went and got a quitclaim. You can only get a quitclaim if somebody's going to give you. A quitclaim is when somebody's giving you an interest in their property, but the purpose of that type of a deed is to say they're giving you only whatever they have, and they can't be certain what they have. It's not necessarily the best kind of deed to receive. So if the question is about if somebody gives you their quitclaim deed on a house, can they benefit after the house is sold? Well, no, they've given you whatever it is that they had. That's the purpose of a quitclaim deed. If the circumstances suggest something otherwise, like being done shortly before a divorce, and then you get divorced, the court's still likely consider it a marital asset that has not been abandoned or waived just because he gave it to you beforehand. So I'm not really sure if that's what you're getting at, because that is a typical issue in a divorce where the party make a partial agreement with something and then change their mind, or it not be a full agreement, and when a divorce comes, you're trying to undo what you did. Usually interspouse transfers are not going to be excluded from equitable distribution, but if you outright transfer it to somebody with a quitclaim deed, you have no more interest in it, simply put. Anybody else? Any other questions? All right, well, I appreciate you coming out tonight. I apologize for the change in schedule. We usually do these the last Thursday of every month, but being it's Thanksgiving, I didn't think you'd want to be sitting by your computer listening to me, so I did it a week early. We will have one next month, the last Thursday. I'm sorry, I don't know the date or the topic offhand. I forgot to check before I got on today, but it will be at 6:30. And I hope you can attend. Invite anybody you know may benefit from it. You'll get emails about the topic shortly. If you happen to think of some questions after I sign off, feel free to email me. My email is Brad, B-R-A-D, at micklinlawgroup.com. That's MICKLINLAWGROUP.com. With that, I'm going to wish everybody a good night, and I hope to see and have you here next